Thank you, Chair. Ms. Litton, I'm going to start with the first thing you said. You told the tribunal that apart from your vast papers you've written, you actually have testified as an expert in matters of this nature. Is that right?
Yes.
And can I put this to you that you've testified in those matters, not as a supporter of a complainant, but an expert and intellectual helping a tribunal reach a decision, right?
Correct.
And I'm going to put a couple of things to you that you should know then, because you've testified as an expert before. Would you agree with me let me set these principles as an expert now, just as principles of expert evidence. Do you agree that expert evidence presented should be seen to be an independent product of the expert, uninfluenced as to form or content by the exigencies of litigation? Do you agree with that principle?
If you can go into what you mean by the exigencies of litigation.
I'm saying you don't have to support one side. You come as an expert, as an intellectual, because you are independent, you are honest, you are frank, you are giving an analysis, but you are not supporting one side in litigation.
Yes, that is the purpose of expert testimony, it's to be a subject expert.
Please, ma'am, just give me an answer. Don't. I'm saying, do you agree?
I agree.
Thank you. The next is, an expert witness should provide independent assistance to the court by way of objective, unbiased opinion in relation to matters within his or her expertise. Do you agree?
That is a general principle.
Do you agree?
I agree.
Thank you. Do you agree that this means that an expert actually should not come to a forum in order to support a particular litigant? Because that is the job of the tribunal, to make a decision, or the job of the different lawyers. Your job is to give a frank, honest, objective, unbiased opinion.
That is correct.
An expert witness should state the facts or assumptions upon which his or her opinion is based.
That is correct.
An expert should not omit to consider material which could detract from his concluded opinion.
That is correct.
Do you agree with me that an expert who omits things that they think may not be consistent with their finding or conclusion is not an independent expert?
That would be correct.
Yeah, so an expert who has large chunks of things he or she omits because they are not consistent with a particular line of his conclusions cannot be trusted.
That is overdrawing an opinion. I think there needs to be asked why things, what has been looked at and what has not been looked at.
You are a witness. You're not going to be an expert with my questions. I'm asking you. You cannot trust an expert witness who omits large chunks of things that are not consistent with the conclusion she wants to make. She must consider everything that is found in the record in order to give an intellectual input. She must assess, including the things that may not be consistent with what she or he likes.
As a general statement?
Well, as a specific statement?
Same thing. It's a general statement. You need to give a specific example.
No, I'm saying if you omit certain things, it will impact on your opinion, on your evidence, as an expert who's supposed to be independent.
As a general point, yes.
And so a tribunal cannot and should never, trust an expert who supports a particular version or is sympathetic towards a particular version in that litigation. You should agree with me.
As a general point.
Now, ma'am, you keep saying as a general point. You want us to engage in this? You're trying to be clever with me. I'm asking you, a tribunal should not. Lisa Vitten, you are an intellectual and I respect you. And I think this is something we must engage in. That a tribunal calls an expert not to support a litigant, but to give them what they don't have, which is an expert objective opinion that takes into account a variety of incidents that have happened that are found in the record. Surely you know this.
No, that I would agree with. If there's what there is in the record, that is what one goes on.
And so the expert who cherry picks, if we find in litigation that the expert cherry picks what suits them, what is sort of consistent with what they want, cannot be trusted by a tribunal.
I was asked to give evidence on sexual harassment. And looking at the general context in which sexual harassment occurs, that is how I read the record.
You remember my question to you?
I'm explaining to you, when you're asking about omitting, there are particular things you're going to look for because you're being asked to look in relation to sexual
You remember
harassment.
my question, Ms. Better? Please, I don't want to be rude to you, and I don't want you to try to be smart with me. Let's be civil with each other. What was my question?
Your question was whether or not it was about the omission of evidence and whether or not people can be trusted if they omit evidence.
Yes, I'm saying, should a tribunal trust a so-called expert or intellectual who cherry picks rather than look at every aspect and give an analysis? Should they trust an intellectual like that or an expert? Because we're not experts here, you are. And we must trust you. Should a tribunal, as a general point, trust an expert who cherry picks and omits certain things in order to support one side?
I suggest an amendment to the question, unless it is a quotation. How about replacing trust with rely? Can the tribunal rely?
Chair, I'll use the words you prefer. But I think they mean the same, because in order to rely on something, you must trust the person who gives you the opinion. But if you prefer rely, that's fine. Can a tribunal, you agree with me that a tribunal, any tribunal, should not trust someone who is an expert who cherry picks certain things and omits others to suit a particular interpretation?
I think I've said to you as a general point, no, you can't.
Ma'am, you keep saying as a general point, then you must be able to tell me what's the other side, which is a specific point.
No, it's a principle. I'm agreeing with you, that's the principle.
Okay, yeah, so please, when I ask whether you agree or not, just tell me you agree, because I don't know what you mean when you say as a general point. The last principle on this that I want to check with you is, and that's where I'm going to go after this, if an expert's opinion is not properly researched, but he or she considers that insufficient data is available, then this must be stated with an indication that the opinion is no more than a provisional one. You agree with that?
That's never been asked before, because what's been asked is to give a basis on how you arrived, the information that you arrived at your opinion. You give it, then it's up to the court to assess whether that was sufficient.
Do you agree with me? Is that a yes?
Yes, if you are clear about what you relied on.
It's fine, ma'am. We have time with you. I'm going to have time with you. Have days and days.